All right, it's 8:30. So we're here for the 8:30 docket. This is Judge Krier again. First case on my docket is the guardianship of James Jesse, 19 GA 211. First of all, let me just check. I think we are on Court Smart. Yes, we are. Okay. Who's here for the guardian?
Good morning, Your Honor. This is Adam Mohammed Boy for the guardian, and also Erica Dines on as well.
Anybody
I'm
else?
also on, Your Honor, Jeff Gennaro.
Okay. Mr. Gennaro, who are you here for?
Pamela Elwell, the guardian.
Okay.
And Your Honor, I'm here for the respondent, Lisa Franzia.
All right. The reason this is set is because I don't know why it's still open.
I agree.
You guys have had plenty of time. Get this case closed. What's the problem? The ward is deceased.
Yes, Your Honor. If you'll recall from our April status conference, the ward has passed away. There are two other lawsuits pending. There's a will contest. And
yes, but not in the guardianship case.
Yes, Your Honor. And because of the will contest, no PR has been appointed. There's a petition.
That's not my problem. This case needs to be closed. You will have to figure it out. But we're not going to keep this case. You cannot keep these cases open this long. So I'm giving you to the end of the week to file your petition for discharge and get your final accounting filed. If you do not do that, I'm closing the case without releasing anybody from liability. So get it done. I've given you plenty of time to get this done. And there's just no reason that we do not have this case closed, including the issue of the injunction can be handled in the probate case also.
Well,
if I may, Your Honor.
Okay, who's speaking?
It's Erica Dine, Your Honor. If I may,
Yep.
The way that the guardianship statute says is that there is not a discharge until a PR has been appointed. So under 744, until a personal representative or even a curator, which is what we were hoping for, is appointed, then we have 45 days from that date.
Well, you guys have been dragging your feet on this. I am not going to allow it.
We're not dragging our feet, Your Honor. I'm sorry to interrupt you, but we're not dragging our feet. The PR issue cannot be resolved until we are heard, and that hearing wasn't set for way out.
Who is this in front of?
I'm sorry, Your Honor. Adam can tell you who the judge is. I don't off the top of my head recall. However, it's what we talked about with you in April. The delay in getting a PR appointed has to do with the time of the other judge, not you.
Who is it in front of?
Case, not the guardianship case. I'm not the attorney of record on the guardianship case, which I understand based on the letter that I had to send to your office because Mr. Mohammed Boy added me to the service list back in June. Anyway, this is the incapacity case. This case is petition to determine incapacity. It has nothing to do with the guardianship case. They're trying to conflate the two of them to keep this case open because they want the injunction out there against her so she can't.
No, that's not true, actually. The incapacity case was incorrectly filed.
Okay. Nobody's answering my question, which is what judge is this in front of, the probate case?
I'm pulling it up now, Your Honor.
It's Hayes, Your Honor.
Okay.
Well,
the
Judge
first
Hayes
thing that's going to happen is I'm going to have that case transferred to me. I have a lower case number, so it should get transferred to me.
Which is what
I'm going to get this set for a hearing on this in June. And thirdly, I'm going to investigate whether or not I can close this case on my own motion, which I believe that I can. And if I can, I will be closing it because I have given you guys plenty of time to get this done. When did he pass away? Like the first of the year, the end of last year?
I think it was August 2020.
Of last year.
Yes.
Yes, and here we are.
Your Honor, if you may recall from the last status conference, we discussed getting the cases in front of you. You asked me to file motions to transfer in the other cases, which I filed within 2 days. You indicated you were going to talk to the clerk about transferring them in front of you.
Okay, but you didn't send me the motion. I don't regularly review all 800 of my probate and guardianship cases every day. So yes, I don't know if
I did send it along with a cover letter, which is what Mr. Silverfield responded to. The problem with the other judge is that we didn't have hearing time until October or November. So we have this petition to appoint a curator sitting out.
Well, number one, send me just give me the case number and I can take a look at it.
The case number for the civil action is 2021 DA 691. And the case for the estate is file number 20 CP 3040.
30, 40. Okay. So I will look at both of those cases, and either I or somebody else will be ruling on your motions to transfer, assuming that they're in the file, because I have never seen them.
Your Honor, I've also sent you a motion, I'm sorry, a memo of law regarding the closure of a guardianship when we first had a status conference. If you like, I could resend that to you as well.
That's fine, but be warned, I'm going to do my own research. I don't really care what you say. I'm going to be doing my own research.
If their only reason for keeping it open is because of the guardianship, then
I'm aware, Mr. Silverfield. I'm aware. The question is do I have the authority to close it on my own motion? If I do, I will be closing it. If I don't, then I won't. But my understanding is that I do. So I will research that and review Ms. Stein's memorandum. If you have other information, Mr. Silverfield, feel free to forward it to me. All right. Very disappointed in all of you. Very disappointed. All right. That concludes this hearing. Thank you, Vince. All right. Next case is Samaya Perdomo versus Garmathy and Associates, 20 CA 72. Who's here for the plaintiff?
Good morning, Your Honor. Mark LaValette for the plaintiff.
All right. How do you pronounce your last name? LaValette.
LaValette, yes, Your Honor.
All right. And who's here for the defendant?
Mark Beebe, Your Honor.
All right. This is a joint motion to remove the cause from the trial docket. And I must have missed it because I think you filed two motions. One, if I'm correct, one did not have a trial date. Usually when somebody doesn't give me a date for when they want to continue something, I set it for a hearing because I have to have, I don't just take things off the trial docket. But it looked like you guys want to be set or are set in September. Am I correct about that?
Your Honor, I'm not aware of a trial date specifically, but that seems fine.
Okay.
No,
Well,
I can tell you the trial date, Your Honor.
I'm looking at your joint motion
I'm
and I'm looking at the attached case management plan and it says
Correct.
August 2021.
Your Honor, I believe the September 13, 2021 was when it was currently set.
Correct, Your Honor.
Okay, well, I'm looking at your joint motion that was filed on 4/29, and you attached a case management plan, which I assumed was a new one. That's the old one?
Yes, Your Honor, that's the old one.
Okay, so when do you want to have your trial then?
Well, so Your Honor, given the fact that the Supreme Court has just come out with a new administrative order, which will force all cases to be presenting new administrative orders, we haven't yet discussed this with Ms. Beebe. However, the intention of the plaintiff was to reach out to the defendant and develop a new trial case management order.
No, I'm asking you, Mr. Lavalette, when are you going to be ready to go to trial?
Your Honor, again, this is a joint motion. We would have to discuss this with maybe Ms. Beebe further. The intention of the party was to conduct more discovery.
Well, then your motion is denied. Okay, you come into court with no idea when you want to have a trial. Ms. Beebe,
Your Honor, I would propose having it in October or November. We've done our discovery on our end. We're just teeing up some expert issues. I think by October or November, this should be fine. So I would only ask that it be bumped for a month or two, please.
All right, I've got a September 13th through October 15th trial period, and then I've got an October 20th through November 12th trial period.
I would suggest October 20th, Your Honor.
Okay.
Your Honor,
I also have a November 17th through December 17th trial period.
Yeah.
I mean, that always gets tricky because of the holidays, but.
Your Honor, as far as the plaintiff is concerned, November would be fine. I heard Ms. Beebe mention that.
I would suggest the October 20th trial docket, Your Honor, which is basically the end of October, beginning of November. I would prefer not to have it over the November 17th, just because it's hard to get a jury and with all the travel issues.
I'll put you in the October 20th through November 17th trial period. And that pretrial is September 9th. Have you guys arbitrated yet?
I don't think this is a 4-day trial, Your Honor, unless your intention is to send every case to the non-binding arbitration. I would prefer not to.
this is not a 4-day trial?
Won't be a 4-day trial, Your Honor.
Okay. And it's not a Hurricane Irma case?
No, ma'am.
No,
Okay, then, yeah, you do need to mediate, but you can mediate whenever you want. Okay, so we'll issue a new trial order. I will need an order from this particular proceeding, and we'll send out a new trial order.
Thank you.
And you guys, if you want to adjust your deadlines, that's up to you. I'm fine with that. Just send me a stipulation. But if you can operate without a written stipulation, that's fine too. It's just oftentimes it's better to have everything in writing.
Thank you, Your Honor.
All right.
Good order.
Next case is Massey Construction versus Heritage Insurance, 19 CA 3193. Who's here for the plaintiff?
Good morning, Judge. Steve Carestes for the plaintiff.
All right, and anybody here for defendant?
Good morning, Your Honor. Dean also here for defendant.
All right, so this is plaintiff's, Mr. Crusty's motion to withdraw. So one more, Mr. Crusty's?
Yes, Judge.
All right, anything you want to tell me? Mr. Nwasu?
We're not objecting to the motion of withdrawal, Your Honor. We just need to figure out how we're going to handle the upcoming deadlines in a non-binding arbitration in June. If we obviously get that stayed, depending on appointments by new counsel.
Yeah, well, what I'm going to do is give them 30 days to hire new counsel, 30 days from today to hire new counsel, which will abate everything for 30 days. So if you've got stuff scheduled, you're going to have to push it off, but you can just push it off 30 days. But I can't force them to go ahead without counsel because they are an entity. And so, Mr. Cresses, you need to include the language that you've been including in all your orders, that they have 30 days and the consequences for not obtaining counsel.
Yes, ma'am.
All right.
Your Honor, just clarify that non-binding arbitration, I think it's scheduled for June 14th. So would that be canceled and stayed another 30 days, or how is that should be addressed in the order?
Well, you guys are going to have to reschedule it.
Okay, we'll reschedule, Your Honor, not an issue.
Yeah. All right. Thank you.
Yeah.
All right. Next is Mary Pizzo versus Walmart, 19 CA 3961. Who's here for the plaintiff?
Good morning, Your Honor. Gunther Fernandez here for the plaintiff, Mary Pizzo.
All right. And who's here for defendant?
Amanda Ross on behalf of the defendant, Walmart. Good morning, Your Honor.
All right. So this is plaintiff's motion for leave to amend the complaint.
Yes, Your Honor.
Pretty old case, and you guys are set for trial.
And I agree, Your Honor. And we also have a case management agreed order that said we actually are allowed to amend all the way up to May 23rd, and we're doing it timely.
Any response?
Yes, Your Honor. We filed a response, but it was filed yesterday. So if you just briefly allow me to respond.
Sure.
You are correct. We have a June 30th trial date. Discovery is clearly closed at this point. And while we're cognizant that the case management order allowed amendments up through May 23rd, it's clearly prejudicial at this point, and the court has discretion to deny the motion for leave. It's a general negligence slip and fall on a hanger, which is by law a transitory substance. So the original complaint was just a general negligence complaint for negligent maintenance, inspection, and warning. However, the motion to amend and proposed amended complaint, it's not just a motion to conform to the evidence, which I really wouldn't oppose. There's specific new allegations and theories of liability, such as negligent training, negligent mode of operation, which we contend is not even a viable cause of action, and negligent selection of the flooring. There's 2 counts. We believe they're the same allegations, although plaintiff has separated them out into 2 proposed counts. And these new theories of liability would certainly require us to conduct additional discovery, because issues such as training and the selection of flooring were not investigated or discovered as the case was going on. Because the court has discretion, we would ask that the court deny the motion. I'd also like to point out, we've already proceeded through arbitration. There is an arbitration award. The plaintiff moved for a trial de novo, but that award was issued on the operative complaint at this time. So that is certainly going to frustrate the proceedings if we go to trial on new theories of liability and then try and backtrack in terms of a prevailing party when the arbitration award was issued on different causes of action.
All right. And also, just so you know, you guys are set for trial in July. Your pretrial is actually next week. So
Correct,
Right,
Your
Mr.
Honor.
Fernandez, response?
Yes, Your Honor. The motion to amend the complaint not only discusses that, it also discusses the location, and most of the stuff that we are alleging at this point came out of discovery. We are alleging negligent entrapment because we can see in the video.
But Mr. Fernandez, you're representing the plaintiff. You have all the discovery. I mean,
Well, at this
your
point,
client-
yes, Your Honor.
you know,
But
your client should have been able to tell you I slipped on a hanger or whatever.
Yes, Your Honor, I agree. But with regards to the additional claims that we're making, we received that through discovery. The reason why we're claiming negligent entrapment is because we can see the Walmart employees walking around the area with their cell phones. After taking the positions, we found out that they were not supposed to do that. They're not supposed to be walking around with their cell phones, talking to each other. And we got all of that information through discovery with the positions and after receiving the videos from Walmart. Same thing with modus operandi as to the fact that they are the ones that actually created danger because that's their own hanger that they use. And again, we got that through discovery, and that's the only way that we can be able to prove that. I cannot make an allegation without having proof. And at this point, we have that because we have concluded discovery, we have done it, and more importantly, we have an agreed order. It was agreed by both parties that we were going to be allowed to amend our complaint at this point, all the way up to May 23rd. So it's unreasonable to say, oh no, it's too late now, when we had agreed previously, both parties signed that agreed order.
But the court did not agree, Mr. Fernandez. So that is moot to me. If you want to argue that, that's fine, but don't hang your hat on it.
Okay. Well, Your Honor, I believe Your Honor did sign the agreed order. But anyways,
I did not agree to you guys amending up until the time of pretrial. So. Oh, sorry about that. Go ahead, finish up.
Yes, Your Honor. And again, we're not just amending that, we also are amending the location of where the accident happened. Initially, that was not clear, and we're amending that as well in our complaint. So I don't believe it's prejudicial. I don't think there's actually need for any additional discovery or depositions or anything, because we're claiming stuff that the defendant would know. So I don't know how they're going to be taking the position from my client, because we have this knowledge based on the discovery that we obtained from them. It's clear and settled law that allowing a plaintiff to amend the complaint, it should be allowed. It's only when the plaintiff completely and outright abuse the discretion to amend the complaint, which again, we're not. This is the first amended complaint that we're doing, and we're doing it based on discovery, that we're requesting this change.
All right, everybody mute your cell phones, please. All right. Well, the motion is denied. This is an abuse of discretion. It is prejudicial. You had all of the information just like the defendant did. Your client should have known why and how she slipped and fell or tripped and fell. And it's a 2019 case. Pretrial is on Monday. And this, regardless of what you guys stipulated to, if I grant this, first of all, it's going to completely knock off the trial schedule. And the Supreme Court has set certain guidelines in terms of, when these cases are supposed to be resolved, which we're already outside because of COVID. So we need to move this along, and it does not appear that there is good cause that I would allow this. Amendment. Normally you are correct. Amendments are liberally provided, but not in this case. So I'll need an order from you, Ms. Ross, after you've circulated it, forwarded to my office email address in Word format, please.
Yes, thank you, Your Honor.
You guys remain on the pre-trial docket. All right, next case.
Your Honor,
yes.
may we please be advised as to the ruling and the reasoning as to why the court does not.
I already made my findings, Mr. Fernandez.
I agree, Your Honor, but I just want to know what the rulings are themselves. I know.
I made my findings, Mr. Fernandez. I hope you were listening. I denied your. Motion, and I made findings.
Yes,
I'm not going. Okay, Mr. Fernandez, I'm done with this hearing. We're moving. On now, sir. Ms. Ross, I need an order from you.
Thank you.
Right, next case is McSpadden versus United Property and Casualty, 19 CA 48. Who's here for the plaintiff? Anybody?
I thought this came off.
Okay, maybe it did. Next is El Kamadi LLC versus Universal Insurance, 20 CA 2758. Who's here for the plaintiff?
Scott G. Millard. Good morning, Your Honor.
Good morning. And who's here for defendant?
Paul Crochet for defendant, Universal.
All right, this is a Hurricane Irma case. This is defendant's motion for a more definite statement. So go ahead, Mr. Crochet.
Yes, Your Honor, this is a 2-count complaint. The plaintiff is a commercial property owner who had a policy with Universal. count of the complaint is for equitable relief to compel the insurer to go to appraisal. And the second count is also a breach of contract count that asks for the court to compel Universal will go to appraisal, but it also looks for economic damages. The main purpose of the motion for more definite statement is to get a more definite statement as to what damages the plaintiff in this case seeks, because the only allegations in the complaint concerning defendants' alleged breach of contract.
Well, wouldn't it also seem to me that since these are actually not causes of action for economic damages, but rather for appraisal, that the economic damages are, it's not really the issue of what are the economic damages. The issue is why are they even in the complaint?
I agree. This complaint appears to be directed to appraisal. There is a little allegation in count 2 about economic damages, and so we're just asking for a more definite statement. As this court is aware, the recent case of Citizens Property Insurance versus Manor House from the Florida Supreme Court earlier this year in 2021 states that extra contractual damages are not allowed until after the first party case is concluded. And that's why we're just seeking for a more definite statement. In this case, they're just seeking appraisal. So what else are they looking for?
All right, Mr. Millard, response?
Thank you, Your Honor. The second count for breach of contract doesn't ask for economic damages. And I haven't heard a paragraph point, a citation to the paragraph that Mr. Croce is referring to. The title of the second count is breach of contract against Universal, breach of duty to appoint competent and impartial appraiser. It asks to find that they are in breach for failing to do what the policy required. It doesn't ask for a judgment of economic damages. It does say that we're entitled to attorney's fees and costs if we prevail. So the reality here is we came here on for entry of a default. You ruled on February 8th, 2021, that we would set aside the default and resolve the case on merits. One of my issues was I'm not seeking money. I'm just seeking to engage in this appraisal process because there was coverage open. The order we agreed to was that they would file, Mr. Crochet's client would file an answer. It says an answer within 15 days. This is what followed this motion for more definite statement. I'm not asking for financial damages or money damages.
Well, what you're asking for is in your wherefore clause at the end of count 1 is prejudgment interest on all overdue payments, costs, and attorney's fees, and all other remedies the court sees fit. You demand a jury trial in that one, and then
Paragraph 54 also.
I'm looking at 56 asks for attorney's fees, and then the wherefore clause at the end of count 2 asks for awarding economic damages, but I think if you read the whole thing, it says plaintiff demands judgment against Universal, compelling Universal to appoint competent and impartial appraiser to determine the amount of loss and awarding economic damages. My reading of this is that what you're asking for is for the appraiser to determine the amount of loss, not for economic damages in and of themselves, and then plus prejudgment interest, costs, and attorney's fees. So where are you looking, Mr. Crochet, where are you looking that they're asking for money?
It's paragraph 54. I'll go ahead and read it out loud. It says,
I'm looking at, it says they have been damaged in the form of economic damages, interest, costs, and attorney's fees.
If it's on the record.
But I don't really think, your motion's denied. I don't think you need any more definite statement. I do think this is sort of a ridiculous complaint because, so we get the appraisal and then what are we going to do? There's going to be another cause of action, but nevertheless, this is what we've got to work with. So you need to file an answer, 10 days.
Sounds good, Your Honor.
I'll need an order from you, Mr. Crochet, after you've circulated it, forwarded to my office email address.
Yep, will do. Thank you, Your Honor.
All right, thank you, sir. Next is Orlando Perez. Versus Juliana Toberman, 20 CA 1358. Who's here for the plaintiff?
Good morning, Your Honor. Raisel Ferger on behalf of the plaintiff.
All right. And who's here for defendant?
Good morning, Your Honor. It's actually Heritage Property and Casualty Insurance, and I'm here on behalf of defendant Juliana Toberman.
Okay. So this is a motion to extend case management deadlines. I did not see when you wanted them extended to.
Yes, Your Honor. It's a joint motion. We have arbitration set and we're coordinating depositions. The only issue as for the the October trial docket is counsel has 5 trials that month and I'm set for maternity leave. So we're asking the court if they would consider setting the trial for February. We're working to get everything resolved prior to, so it would just be the actual trial to be set for then.
All right, so this is a 2020 case.
Yes.
That was filed April of 2020. And the Supreme Court has directed the courts to make certain exceptions for maternity leave for both genders. So that is more persuasive to me than anything else. Any serious objections on the other side?
No, Your Honor, we do not have any objections to that.
All right, so we'll put your trial then, my docket for 2022. I have a docket that runs January 12th through February 11th and one that runs February 16th through March 11th. I'm assuming you're talking about the latter one, correct?
Yes, Your Honor.
Okay, so get me an order from this hearing and we'll issue a new trial order.
Great. Thank you very much, Your Honor. Thank you, counsel.
Thank you. Good luck.
Thank you, Your Honor.
All right, next is Scarlatti versus the State of Scarlatti, 19 CA 4725. Who's here for the plaintiff?
Your Honor, John Hooley on behalf of Anthony M. Scariotti.
All right, and for defendant?
Catherine Cook on behalf of the estate.
Got it.
Your Honor.
Go ahead.
I've taken a look at everything. I filed a motion to strike the defendant's motion for mediation. I think, and normally I send a copy of my motion ahead of time. I think I made a phone call and never got a return phone call, but I think this is a waste of the court's time. I think with the agreement of Ms. Cook, we could deal with the motion to compel mediation. And I make that statement with the acknowledgement that we have a Monday pretrial. So if Ms. Cook's willing, we might as well just go ahead with the substantive motion.
Well, so somebody's contesting whether or not you should have mediation?
I'm contesting, Your Honor. We already went through arbitration, and the issue is this. My client paid the decedent full payment for property. They had this agreement. And so if full payment wasn't made, it'd be subject to the statute of frauds. We contend that full payment was made. We have the decedent making marks on an amortization schedule. So we've really got a true issue. We've got a pending motion for summary judgment by the defendant, and we've got a pretrial on Monday. And I don't think we need to, we're not going to mediate, because I'm sure that my client won't accept anything less than a transfer of the property. And I'm sure the defendant, the state, will not agree to that.
All right, Ms. Cook, what's your thoughts on this?
I did file, the defendant filed a motion to compel mediation based off the agreed case management plan. We had agreed to mediate the lawsuit by November 30th. And as counsel said, the mediation did not occur and arbitration occurred. We reached out and requested that the mediation be scheduled, but our request was ignored. So we filed the motion to compel. We still believe it would be beneficial for the parties to mediate the claim as they were supposed to, according to the original case management plan and order.
Well, are you guys ready for trial?
Yes, Your Honor.
Yes.
Ms. Cook? Okay. Well, you know, my docket for July is conditional. I only have 2 weeks in July. And then I'm backup judge for the criminal judges. So I'm not sure whether you'll be going to trial or not, but my concern is that it's usually always a good idea to mediate, because I can't tell you how many times people have told me when I was a mediator that we weren't going to settle our case, and 99% of the time we did. So,
I just think we're in an intransigent place, Your Honor.
Well, your client needs to understand it may not turn out the way he wants to turn out, and this is his only opportunity to actually have any control at all over the situation. So what I'm going to do is continue you for a month, put you in August. And well, actually, I don't really need to do that, because you guys are set for July. This is plenty of time to mediate it. So yes, I'm going to grant your motion to compel. I'm going to deny your motion to strike. And you just need to mediate it by the end of June.
Okay, Your Honor.
I'm going to keep you on the trial docket.
So let me make a suggestion as well. We're on the 11 a.m. pretrial. Can we consider this the pretrial?
No, you cannot.
Okay.
Sorry.
I'll be there on Monday, Your Honor.
Well, you just have to be on Zoom. You don't have to be in person. Okay.
Not a problem. I'll do whatever the court wants.
Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Hold on. All right. Next is Persons versus St. John's Insurance. This is 20 CA 4000. Who's here for the plaintiff?
I am, Your Honor. Good morning. Gabriella Ibanez Ehlers for the plaintiff.
Right, and defendant?
Good morning, Your Honor. Mark Projectva for the defendant, St. John's.
All right. So this is your motion, or plaintiff's motion, to strike affirmative defenses, or a motion for more definite statements. So go ahead.
Yes, Your Honor. Counsel for the plaintiff filed a motion to strike.
Just so you know, you guys only have 15 minutes. So
correct.
You each have 7 minutes apiece. Go ahead.
Defendant filed 7 affirmative defenses, including a reservation of rights. We took issue with the first 5 and the reservation of rights. We found that they are missing policy language, quotations, and ultimate facts that would allow the plaintiffs to ascertain what the defendant's defenses are. They're also mostly just conclusory allegations as well as denials, which are not appropriate for affirmative defenses.
All right, response? The first 5 you said?
The first 5 and then the reservation.
And then the reservation, yeah, okay. Go ahead.
Judge, our first, I guess if you'd like to go through each of the 5.
Yes, I'm happy to go through each of the 5.
Okay, so the first one is our catch-all, essentially saying that this is a breach of contract action and the policy controls.
Right, which is just a denial and should be stricken. It's not an affirmative defense. Number 2.
Is that with leave to amend?
No leave to amend on number 1. Number 2.
Number 2, I'm okay with striking it.
My thought about it was I'd give you leave to amend on striking it if you want. If you don't want, that's fine. That looked to me as though you might, and again, you don't have to have a lot of facts, but you have to have a few.
We'll take leave to amend.
Okay. Number 3 was the same thing. Strike with leave to amend. Again, vague, no facts, and we are a fact pleading state, so you have to allege a few facts. Number 4 is just a denial. So that's stricken without leave to amend. Number 5, I don't know. Why don't you talk to me about number 5?
Number 5 is the one.
It looks as though there's a great deal of facts that are alleged in number 5.
Right, and that's the one I take the most issue with, and I think that I'm not sure how I can make that more specific.
Right, I don't either. So it's motion to strike is denied on that one. The catch-all at the end, reservation of rights to modify, that's stricken. You, of course, pursuant to the rules, have some ability to modify, but you don't need to put that in as an affirmative defense. So, Ms. Allers, I'm going to need an order from you after you've circulated it to my office email address in Word format.
Sounds good.
All right, thank you, counsel.
Thank you.
Next case is Zulo versus Tower Hill, 21 CA 347. Who's here for the plaintiff?
Steve Johnson for the plaintiff, Your Honor.
All right. What was your last name, sir? Johnson. Okay.
Johnson.
And who's here for the defendant?
Good morning, Your Honor. This is Elise Maloof of Wickersmith for the defendant, Tower Hill signature.
All right. So this is defendant's motion to dismiss the complaint for a more definite statement. So go ahead, Ms. Maloof.
Thank you, Your Honor. Just by way of background, Your Honor, this complaint was filed in February of this year, and appears to be an Irma Clay case, although Irma is not, stated in the body of the complaint. There's just a date of loss. We filed a motion to dismiss for failure to state a cause of action, and in particular, to failure to plead sufficient facts in the complaint. As Your Honor is aware, Florida is a fact pleading jurisdiction, and under the rule of civil procedure 1.110, claims must state short and plain statements of ultimate facts showing entitlement to relief, and there has to be sufficient particularity to allow the defendant to respond. In our motion, we set forth the sort of deficiencies with the complaint we have here. Most importantly, it doesn't say why the loss was covered under the policy, which part of the contract was breached and how.
Well, I don't usually require that people set forth the specific policy provisions specifically because, I just don't. But your other statements in there with regard to I can see that it's completely unclear as to, so what was damaged? Was it the roof? Was it, what was it? You gotta say something.
Correct, Your Honor. And I understand if you don't require specific policy provisions, and I agree. I don't believe that's necessary. But it doesn't. The complaint doesn't specifically state what is the covered loss. Was it windstorm, or was it water damage, or what is covered on the policy that would require this to be a covered loss? And again, it's not really clear. I don't see the word breach of contract, if this is a breach of contract case, anywhere in the complaint. So in some regard, it is conclusory to that effect. The main claim is that plaintiff gave notice of damages to the defendant and that defendant refused to pay. That's essentially what this complaint says. As Your Honor's read, sorry, go ahead.
No, go ahead.
I was just wrapping it up. We'd ask that Your Honor grant our motion to dismiss without prejudice, with obviously leave to amend to plead more sufficient facts in that regard, or alternatively for a more definite statement pursuant to 1.140.
All right, Mr. Johnson.
Yes, Your Honor. Here, the complaint is more than adequate to meet Florida's pleading requirements, as well as to state a claim in the straightforward breach of contract action by an insured against your insurance company. The complaint alleges that the plaintiff is the owner of a home that was covered by a policy issued by the defendant, that the home suffered storm damage, specifically to the roof, and it attaches an estimate for repair, that the damages are covered under the policy of insurance that Tower Hill issued, that plaintiff provided Tower Hill with an estimate that required a full roof replacement, and that plaintiff's insurance company failed and refused to pay the full property damage. These allegations adequately apprise Tower Hill of the nature of the plaintiff's claim and provide sufficient ultimate facts in support thereof. I don't believe that the defendant has specifically stated how the complaint is deficient, other than it doesn't state that it's a breach of contract action.
All right. Any response, Ms. Maloof?
Your Honor, I just reiterate the facts that are already, or the arguments that are already in our motion. That doesn't say exactly what the cause of loss is, how this was covered under the policy pursuant to the contract. If this is a breach of contract case, surely the plaintiff should sufficiently plead what exactly was covered under the policy and why it was denied. So, I mean, again, based on the written motion that we had, we'd ask that Your Honor grant the motion.
All right, I am going to grant the motion for a more definite statement. I find that specifically there's little specific allegations about how the contract was breached. Was it non-payment? Was it refusal to cooperate with appraisal? Those are just examples, as well as the nature of damages. In my estimation, you don't have to list every fact that's relevant, but you have to allege some. So you can say damages including roof damage, and including but not limited to roof damage, water damage, whatever. But you have to allege something. And I think we've all across the state of Florida been way too lax in not requiring everybody comport with the law. So I am granting the motion. I'll give you 20 days to amend, and then 20 days to respond after that. All right, so I'll need an order from you, Ms. Maloof, sent to my office email address after you've circulated it to opposing counsel.
Okay, so is it the motion to dismiss is granted, or the motion for more definite statement? Or
motion for more definite statements granted.
Okay.
All right.
Thank you.
Thank you,
Your Honor.
Yep. All right. Next, I have two cases left that are longer hearings. Did I miss anybody has a shorter hearing? Okay. Next case is Ramirez Chico versus Summer Lakes. This is 20 CA 1848. Who's here for the plaintiff? Anybody? How about defendant?
Yes, Your Honor. Brooke Sable for the defendant. The plaintiff, there might have been some confusion because the plaintiff yesterday in the afternoon sent over an email that they were not contesting they're not contesting the motion, would agree to it. We sent an agreed order, but it was my understanding from the communications with the JA that we still had to appear today. So that's my guess as why.
Okay, so you guys have agreed to this then?
Yes,
what did you agree to?
We essentially a bench trial. We had moved to strike the jury demand based on a contractual provision to a bench trial. They agreed. The only question I guess I would have, Your Honor, is we're currently on the November trial docket. If we're already on the November trial docket, should we submit a new trial order or anything?
No, you're fine.
Okay.
You're fine. I just need an order from you you've already sent me an order. So when we get that, I will make a note to my case manager that we just need to, in our record keeping, make sure this is a non-jury. And what I usually do with the non-juries is I fit them in. I'm hoping that we will be open, that the courthouse will be completely open then, and I'll fit in my non-juries in and around my jury trials.
Okay, great.
Okay, good enough. Thanks, sir.
Thank you, Your Honor.
Next case is Estate of Barbara Rubinton versus the Arlington of Naples, 19 CA 362. Who's here for the plaintiff?
Donna Haynes, Your Honor.
All right, and who's here for defendant?
Good morning, Your Honor. Drew Levin on behalf of the defendant, and I believe we have a court reporter.
Do we have a court reporter?
Yes, Judge, I'm here, Eric French.
Okay. This is defendant's exceptions to the general magistrate report. There's several problems here. One is which I did not set this. And I always set these. You guys set this on your own. That is not the procedure. You have to send, we usually get these exceptions from the magistrate's office, and then I issue an order that sets forth the hearing time as well as what you need to do. The second problem is because of that, and I don't really know how it happened, but I don't see a transcript in the file from the magistrate hearing. And this is an appellate proceeding, so I have to have the transcript to be able to review the transcript and determine whether or not the magistrate has abused discretion or committed an error as a matter of law. So Mr. Levin, these are your exceptions. What's the scoop here?
Well, the hearing was, in my understanding, the hearing was set by the plaintiff. So in terms of that, we agreed to the date and time, but I can't say that we understood that procedure of Your Honors was not being followed.
Well, the procedure is in the rules, okay? I mean, you have to file a transcript or I deny your exception. So, I mean.
Well, in terms of the transcript, I can certainly provide that to the court at our.
Rule requires you provide it 48 hours ahead of time.
Well, let me just verify whether or not it was, whether or not I have it.
Ms. Haynes, did you see it in the court file?
I thought it was filed, Your Honor. I'm trying to
Kathy, did you see it in the court file? Because I didn't see it, but you know, sometimes things get mistitled, so maybe it's titled under something else.
It wasn't. Actually, can you pull up piano?
It is not in the file. The only transcript in the file is the deposition.
Yep, so I can't proceed today.
I would respectfully ask for the court's permission and ask Ms. Haynes if she would not object to me obtaining the transcript immediately and providing it to the court, and then waiting for the court to set us at the appropriate date and time for this hearing so that we can follow the proper procedure.
Well, I mean, Ms. Haynes, what's your?
I would ask that the court deny his request for exceptions based on the fact that there was not a transcript filed.
All right, let's see. I'm just looking at the rules here. Okay, so the rule, this is rule 12.490, and it provides in 490 subparagraph G, or let's see, F and G, and provides that for the purpose of a hearing on exceptions, a record substantially in conformity with this rule must be provided to the court by the party seeking review if necessary for the court's review. The record must consist of the court file, including the transcript of relevant proceedings before the general magistrate and all depositions and evidence presented to the general magistrate. A transcript of all relevant proceedings, if any, must be delivered to the judge and provided to all their parties not less than 48 hours before the hearing on exceptions.
Well, again, Your Honor, I would just ask that because the party seeking review today was.
Okay, but you're the party seeking review. You filed the exceptions. They just set the hearing, unfortunately mistakenly, but nevertheless, you are the party seeking review. So here's what I'm going to do. I'm going to continue this. It needs to get reset. And I'll make a note of that. I'm going to just have my judicial assistant find a date and time and set it. You did set it for the correct amount of time, though this is an appellate proceeding. It's not a new trial or a new hearing or anything like that. So reset, I'm going to try to get it reset in the next 30 days. And we'll issue an order. And in the meantime, you need to contact court administration, get a copy of the court smart recording from that proceeding, give it to a court reporter, and they then will transcribe it for you at your expense. And then you need to file it.
Your Honor.
And send me a copy.
I believe that my office did hire a court reporter, a private court reporter for that hearing. Would it be acceptable to contact that?
Oh, sure. That's fine.
I will do that today, and I will ask for it to be transcribed on an urgent basis, and it should be available hopefully in the next few days, and I will submit it to the court appropriately as soon thereafter as I can.
Okay. All righty.
Thank you very much, Your Honor, for your understanding. We very much appreciate it.
Well, it's not understanding. It's just that I imagine that the appellate court will just send it back. So that would be a waste of time, and we're already wasting time. So, all right. Thanks, guys.
Understood.
Have a good day.
Thank you.
All right, Kathy, we have an 11 o'clock. So log back in then.